All right, good morning and welcome to the Nevada State Board of Pharmacy June 2026 meeting. Today is Wednesday, July 15, and our meeting will now come to order. My name is Helen Park and I'll be the presiding officer. We'll start with the Board of Pharmacy mission statement. In regulating the practice of pharmacy, the Nevada State Board of Pharmacy has a duty to carry out and enforce the provisions of Nevada law to protect the health, safety, and welfare of the public. Next, we'll do our roll call. Ms. Crystal Freitas.
Here.
Mr. Richard Tomaso.
Here.
Ms. Shanice Taylor.
Here.
Mr. Adam Forath.
Here.
Ms. Anna Carr.
Present.
Ms. Jade Jacobo.
Present.
Okay, thank you. We have all members present. Mr. Weiss, any announcements?
Good morning, Madam President. Dave Weeks for the record. I know I saw Melissa Shake here, so we have a Melissa Shake, previous board member, so thanks for your presence today. I don't see anybody else, but if they show up, I'll say hello to them. The meeting will be held in conformance with Nevada open meeting law. Certain components of it will be done on Zoom. Public can see people appearing on Zoom to the left, and if people come to the table, they'll be presented on Zoom. One procedural issue. We've met with LCB IT a couple times and their staff. They do a really good job of lining up the appearances as people come in. So we tried to, we don't have all the resources that they have, but we've tried to do that. So the room opened today at 8:30. Staff in Reno greeted people. They did update their names with their item numbers and then test that their video and their camera worked if people were willing to participate in that. So I've got it from a couple boards that you wanted staff to address that, and so board members, sorry. And so we've done that. So we'll just see if it's any better to, so have a great meeting.
Great, thank you. All right, so as our next order of business, the board will open up the floor for any public comment. So if we have anyone in the room or online who wishes to make a public comment, if you're in the room, I ask that you please come forward now. Or if you are online or on the phone, please raise your hand in Zoom or press *9 to have your line unmuted. I don't see anyone in the room. Is there anyone online who wishes to make public comment?
We have one on Zoom, Madam President, Daniel Kim.
Okay, great.
My apologies that I pressed that in error.
Okay, no worries. All right, do we have anyone else? Okay, seeing none, I'm going to go ahead and close the public comment for now. There will be another opportunity at the end of the day for public comment. With that, we'll move on to the approval of the meeting minutes from the June 3rd and 4th meeting. Board members, any discussion on the minutes? I reviewed the minutes. They looked fine to me, and so I'd be comfortable with moving forward with the minutes.
Madam President, Crystal Freitas, for the record, I'd move to approve board meeting minutes from June 4th, 2026.
Anna Carr, second.
Okay, there's a motion by Ms. Freitas. I'll give the second to Ms. Taylor. Any further discussion? Hearing none, all those in favor?
Aye.
Any opposed? Okay, the June 2026 board meeting minutes are now approved. Next, we'll move on to the consent agenda. Board members, any discussion on the consent agenda? Besides, it was a very big consent agenda.
It's not the biggest board book ever, but it's close. There's people saying it is the biggest board book, but it's not.
Well, I just, a comment on that is I appreciate the work that board staff has put together. I am very happy with the consent agenda. So it's nice to see.
In regard to thank Madam President, I mean, and the omissions will happen and those kind of appreciate your patience. It's quite a document.
Board members, I am comfortable with the consent agenda. Any discussion?
Madam President, Shanice Taylor, for the record, I agree, and I do move to approve the consent agenda.
Okay, great. We have a motion. Do we have a second?
Second.
Anna Carr, second.
Let me give it to Anna Carr. Motion by Ms. Taylor, second Ms. Carr. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, the consent agenda is now approved, and with that, we'll go ahead and move into our regular agenda. I will start with agenda items 5L and 5M. That is for Summerlin Hospital Medical Center Pharmacy and Aurelia Hurtado Sadowski. So if we have representatives here or online, if you could please raise your hand or come forward.
Madam President, Crystal Freitas, for the record, I would like to recuse myself from this matter due to my employment with the Valley Health System.
All right, we'll note that for the record. Thank you, Ms. Freitas.
They're coming, Madam President. They have their identification on.
She's unmuted.
Hello, good morning.
Good morning. Jessica Gandy appearing for both Summerlin Hospital and Miss Hurtada Satowski. I'm actually appearing this morning to ask that this matter be continued to the October agenda. There are still some back end issues that are being resolved.
Madam President, for the record, Dave Weef, this was originally scheduled for October and then the stipulation came along and it got moved up. And I got a call from Jennifer, an email saying, hey, could we move it back? But because of the timing and your procedures, it would be better that that was decision made by today.
And then I guess with Ms. Tucker, any objections or?
Yeah, Laura Tucker for the record, I don't have any objections to continue.
Okay, then with that, we'll go ahead and continue this matter to a future board meeting date. And we'll see you back in October.
We'll target October.
Yes, that should be fine.
Okay.
All right,
Thank
thank
you.
you so much.
Oh, and for the record too, the circumstances that related to the accusation have been mitigated by the hospital system. So they put policies in place that were not there at the time that I've been aware of. So
Appreciate that. Okay, we will move next to item 5A, and that's for Matthew Apple or Dr. Apple or representatives. If you could please come forward or raise your hand on Zoom.
Present, yes.
Hi, could you state your full name for the record?
Matthew Elliott Appel.
Dr. Appel, I'm going to swear you in. Join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Great. And will anyone else be joining you today?
Yes, I hope so.
Who should we be looking out for?
I believe her name is Janet Jensen.
and is she an attorney?
She is.
Okay. Do you have her cell phone number?
I did see her log in. I do
Okay.
indeed. It is.
Oh, no, I don't want it. I was gonna say you could text her. It's okay. We'll look again for her. Janet, if you can raise your hand in Zoom so we can identify you. We have a J. Can you give the last two digits of her cell phone number?
00.
All right, we got her. Yeah, that's hers, all right. Do that. We'll see. Janet, if your last two digits are 00 and we've identified you correctly, we've asked you to unmute yourself.
Hi, I should be unmuted.
Great. Hi, if you could state your full name for the record, please.
Janet Irene Jensen.
Great. And then with that, I will turn it over to Mr. Camp.
I can, for the record, prosecuting this matter on behalf of the state. This is case number 24044 PDAS. The named respondent, Matthew E. Appel, MD, certificate of registration number CS 24505 and PD 00589. Refer you to the board book. Page 8785 begins the statement of charges. Respondent's answer was filed beginning on page 8807 of the board book. And we have a stipulation to present to you for your consideration and possible approval today. That is not in the board book. Hard copies have been provided. By way of brief background, this is a resolution with the second respondent in this case. A stipulation was approved by this board earlier this year with the other respondent, Respondent Umbach. And so this will fully resolve the case today. By way of brief background as to the charges, both respondents were charged with numerous violations regarding their inventory of controlled substances with regard to their practice at Blossom Bariatric in Las Vegas. That practice is now no longer maintaining a dispensing practice. And both individuals had allowed their dispensing practitioner registrations to expire. The proposed discipline resolving the matter, which is the same discipline that the other respondent stipulated to and is discipline that is standard for these types of violations, will be that first, with regard to his registration number PD 00589, respondent will have that registration revoked, and he may not petition for a period of 5 years for reinstatement. With regard to the respondent's certificate of registration number CS 24505, it is suspended for a period of 2 years. However, the suspension is stayed and the respondent placed on probation, subject to the conditions of first payment of a $5,000 fine for the violations due and payable by August 14th. Second, a payment of $1,000 to partially reimburse the board for recoverable attorney's fees and costs incurred, due and payable by August 14th. Shall comply with all federal and state laws while on probation, have no additional administrative charges filed by this board, and have no action taken that would be reportable pursuant to Nevada law. And upon completion of probation, those terms, the respondent's certificate of registration number CS 24505 will be fully restored. This is the stipulation we're presenting for your consideration this morning. Thank you.
Great. And then with that, I'll turn it over to Ms. Jensen if there's any additional comments in regards to the stipulation, or if you wanted to add any additional remarks on behalf of your client.
Well, actually, thank you for that. Dr. Appel was an employee of Blossom Bariatric, and he, though he, worked out of the pharmacy, what they did was they had a pharmacy which dispensed only one drug to surgical patients the night before they got surgery. Each patient was given a few painkillers to take so that when they came in for surgery the following morning, they would not experience a great deal of pain. Dr. Appel did not make the decision to have an in-house pharmacy that dispensed only one drug, and he was just merely an employee. And so, and the pharmacy, the practice had a pharmacy consultant. And so it was disappointing. And they did have software, and they did have national, manufacturers supplying them and teaching them. And so the fact that some of the pills went missing was, a consternation to everyone. The DEA, Dr. Appel rightly reported the missing drugs to the DEA immediately. The DEA did a full investigation and did not sanction Dr. Appel, Dr. Umbach, or the pharmacy. So Dr. Appel is happy to put this behind him, but I don't think factually it's as bad as people want to think. And Dr. Appel is a great surgeon. He will have a long and storied career, and I just wanted to put that on the record in his defense. But he is happy to sign the stipulation and put this all behind him.
Okay, great, thank you. And Dr. Appel, since you're here, did you want to make any additional remarks?
No, thank you.
All right, so we'll turn it to the board. So I am comfortable with the stipulation as presented. I don't have any questions or concerns, board members.
I would agree, Madam President. Adam Pork for the record. I would move that we approve the stipulation order for Dr. Matthew Appel as presented by board staff.
Shanice Taylor.
That one, we'll go motion to Mr. Porras, second to Ms. Taylor. Any further discussion? Okay, hearing none. All those in favor? Aye. Any opposed? Okay, that motion passes. The stipulation has been approved. We thank you for your time today.
Thank you.
Thank you.
Thanks. All right, next we'll move to agenda item 5C for Marika Lene Care or Kerr. We have representatives here. If you could please come forward. Please have a seat. Yes. Hi, and if you could state your full name for the record.
Marika Lene Kerr.
Okay, and then will anyone else be joining you today?
No, I was told with the stipulation that I was able to have someone, but wouldn't be needed, sorry.
That's correct. Okay. All right, so with that, I'll turn it over to Mr. Cant.
President Park, do you want to swear the respondent?
I certainly do, yes. All right, Ms. Carrot, if you could raise your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete? Okay, great. Thank you. Thank you, Mr. Camp.
Greg Camp for the record, prosecuting this matter on behalf of the state. This is case number 25146 CSS. Named respondent Marika Lene Kerr, APRN certificate of registration CS 26747. Charging document begins on page 8832 of the board book. Respondent did not file an answer to the charges. There is a stipulation we're going to present to you for your consideration this morning, beginning on page 8845 of the board book. So by way of brief background, the respondent was engaged in practice at Carolina Skin Care here in Las Vegas. The owner of Carolina Skin Care, Carolina Molina, is not a Nevada licensed practitioner, and a board investigator in the course of an on-site inspection determined that respondent had allowed Molina to use respondent's credentials to purchase dangerous drugs, maintain an unsecured inventory of those drugs, and access those medications outside of respondent's presence and without respondent's supervision. And there was independent access, possession, and administration of drugs to patients and on-site medical treatment without direct practitioner supervision. There was also issuance of prescriptions for dangerous drugs to Meta-Pharmacy Services that falsely identified Molina and other individuals as the patient in order to obtain the drugs for office administration. And there was record-keeping issues as well. So in order to resolve the matter, and once again, this is discipline that is standard and consistent with violations of this type. The respondent will have the certificate of registration CS 26747 suspended for a period of 2 years. The suspension will be stayed and the respondent placed on probation, subject to public reprimand, payment of a $5,000 fine for the violations. And I just noticed that the date in there is July 14th, and I would ask that the board amend the stipulation to provide the due date would be August 14th. Oh, no, I'm sorry. I correct myself. It's July 14th next year. Sorry, that's right. That was what we negotiated. The respondent asked for a year to make the payment on the fines and fees. So that is the correct date. The fine would be due July 14th of next year. There would be payment of a $1,000 $1,000 to partially reimburse the board for reasonable attorney's fees and costs incurred. That would also be due July 14th of next year. And the respondent during the period of probation shall comply with all federal and state laws, have no new charges filed by this board, and have no other charges that would be reportable. And upon successful completion of probation, have her certificate of registration CS 26747 fully restored. So this is the stipulation we're presenting for your consideration.
Thank you, Mr. Cant. And then for Ms. Kerr, I just wanted to give you an opportunity to comment on the stipulation if you have any concerns, or are you in agreement?
Yes, I'm in agreement. I have been talking with Mr. Cant. It was my fault for not having the due diligence of understanding how she was running her business. When I did find out about what was happening, I did cut all ties with Carolina Skincare and have not had any contact with her at all.
And you agree to the stipulation as it's?
Yes, I agree.
All right, then I will turn it over to the board for board discussion.
Madam President, can I ask Ms. Kerr a question?
Absolutely.
Hi, Adam Porth for the record. Are you a medical director of any other medical spa at this time?
No.
Okay, thank you.
I don't have any questions or concerns with the stipulation.
I don't have any other questions either. Crystal Freitas, for the record, I move to approve the stipulation and order as presented for Marika Kerr, APRN.
Adam Porth, second.
Okay, we have a motion by Ms. Freitas, a second by Mr. Porath. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, that motion passes. All right, thank you for your time today. Then we are going to move to agenda item 6A for Carolina Molina. Actually, that one has, I have a note that might be withdrawn, or?
Carolina Medina has been withdrawn. They have accepted the terms of the cite and fine.
I think I might go to 5E and F then, since Mr. Cant
Makes sense. Thank you.
the room. So we'll go to 5E, 5F for Irene Benliro and Joanne Mosqueda. Hi, good morning.
Good morning.
If I could have each person state their full name and identify themselves, and then I will swear in the respondents.
Irene Benliro.
Joanne Mosqueda.
Thank you.
Joshua Dickey on behalf of Ms. Benliro.
And David Merrill on behalf of Ms. Mosqueda.
Just the respondents, if you could join me in raising your right hand, do you swear that the testimony that you're about to provide will be both truthful and complete? Great. All right, Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This is for agenda items 5E and 5F. They can be found on 5E can be found on page 8895 of your board book, and then 5F is found on page 8919 of the board book. This is for case numbers 25-266-PD-A-S and 25-266-PD-D-S. Respondents are Irene Mosqueda Benliro, certificates of registration CS 17652 and PD 01110. And Joanne Mosqueda, certificates of registration CS 24366 and PD 27887. By way of background, the allegations that we allege are that while working at Medical Weight Loss and Family Clinic, APRNs, Benliro and Mosqueda dispensed retatrutide to patients, which is not approved by the FDA. Furthermore, the clinic improperly stored medications, failed to maintain and produce accurate records to board staff upon request, held for sale adulterated drugs, and Binlero engaged in unprofessional conduct by purchasing from unlicensed manufacturers and permitted unlicensed distribution of drugs. For this accusation, we had 6 counts. 4 of the counts were for both respondents. Count 1 is failure to maintain security of drugs. Count 2 is holding for sale adulterated drugs. Count 3 is failure to maintain records. Count 4 is possessing, selling, or furnishing drugs not approved in the United States. And as to respondent Binlero only, count 5 is unprofessional conduct for acquiring drugs from an unlicensed retailer. And then count 6 is unprofessional conduct for permitting unlicensed distribution. We have 2 stipulations that were entered into with the respondents. They can be found on pages 8911 of the board book and 8935 of the board book. As a result of this agreement, both respondents' dispensing practitioner licenses are revoked, and neither can petition for reinstatement of their dispensing practitioner license for a period of 5 years from the date of this order. Also, neither respondent may be in possession of controlled substances or drugs at a place of practice for a period of 1 year unless employed by a medical facility, as that term is described in NRS 449.0151, excluding mobile units. The respondents may work at a facility where the drugs maintained are to be used and administered in case of an emergency, and may be in possession of controlled substances or dangerous drugs if the drugs are prescribed to respondents for a legitimate medical purpose. The respondents may continue to prescribe controlled substances and dangerous drugs pursuant to their controlled substances license. For Mosqueda will pay an administrative fine of $5,000 payable within 30 days of the date of this order. And Binlero will pay an administrative fine of $10,000 also payable within 30 days of the date of this order. And then each will pay $1,681.50 in attorney's fees and costs payable within 30 days of this order. So we present this stipulation to the board today for approval with an effective date of today, July 15th, 2026.
Okay, I will turn it over to the counselors.
Sure. Joshua Dickey on behalf of Irene Ben-Lero. Ms. Tucker accurately set forth the agreement that my client has signed off on, and as reflected in that stipulation, my client is taking responsibility for her actions. I'd also note that there was also discipline relating to these events from the Board of Nursing that's in place. And I'd ask the board to approve the stipulation.
Yes, thank you. And I echo Mr. Dickey's sentiments. We worked through the stipulation very well with Ms. Tucker. We asked the board to approve it, and there was also Board of Nursing discipline against Ms. Mosqueda as well. Ms. Mosqueda is here to take responsibility for what was done, and we think the stipulation is tough but fair.
And then just Ms. Ben-Lero or Ms. Mosqueda, did you want to make any comments or remarks? You're not required to, but if you'd like to. Okay, board members, any questions? I don't have any questions. I agree that the stipulation is tough but fair, and it's appropriate, and I would feel comfortable moving forward with the stipulation as presented.
I agree, Madam President. Shanice Taylor for the record. I do make a motion to approve the stipulation as presented.
For both?
For both defendants, yeah.
Okay.
Crystal Freitas, I'll second.
Okay, so we have a motion by Ms. Taylor and a second by Ms. Freitas. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, those motions pass. Thank you so much for your.
Thank you for your time.
Madam President, Dave Weiss for the record. Brett was out, so you called Melina, but I stated that she had withdrawn her appeal of the cite and fine. I don't think there's anything else we need to do, but we just wanted to make sure you had your say.
Yeah, Brett Camp for the record. With regard to the second part of the case 25-146, and that was an appeal of the cite and fine on the unlicensed person. I've been in contact with their counsel, Courtney Sullivan, who was going to appear here today to formally withdraw the appeal, and I was going to ask to have the hearing vacated. Ms. Sullivan was going to fly in this morning, and I think she may be delayed. We can do it without her appearing, but I didn't know if she wanted to note something for the record.
Well, I think why don't we, I knew that the circumstances, I didn't know she was appearing, so why don't we give her the courtesy of that and it's not too late, so we'll just see if she shows up. You can move without it though at the end of the meeting day if you want. And with that, Madam President, I know you're cruising through and I don't want to mess up your speed, but procedurally I need to do a couple things, so if you can take a quick break, I would appreciate that.
We'll take a quick break. All right, so I'm going to call for agenda item 6A for Carolina Molina, our representatives, if you could please come forward. Hi, good morning.
Good morning.
I could have you both state your full names for the record.
My name is Courtney Sullivan. I'm here with my client Carolina Molina, who's present.
My name is Carolina Molina.
Ms. Molina, I'm going to swear you in. Do you swear that the testimony that you're about to provide will be both truthful and complete? And Mr. Cant.
Brett Cant, prosecuting matter on behalf of the state, case number 25146S. This is an appeal of a citation and fine against Carolina Molina. And the original cite and fine document is on page 89 of the board book. Ms. Molina did appeal. That was on page 90 of the board book, and the board issued a 233B statement appearing on page 9093. This is related to the stipulation you approved earlier with Ms. Kerr and concerned the operation of Carolina Skincare here in Las Vegas and alleged violations of law with regard to possessing, administering certain dangerous drugs outside a direct practitioner's direct supervision. My understanding is that Ms. Molina now wishes to withdraw her appeal of the citation and fine and have the hearing vacated, but I want to afford her and her counsel an opportunity to address you.
Ms. Sullivan.
Good morning, members of the board. Mr. Kant is correct. Ms. Molina believed in good faith that she was relying on her prescriber to follow the rules, and she and I have had an opportunity to review the facts and the case, and she believes that the board's cease and desist is a fair and just outcome here, and she appreciates that opportunity. So she would ask to withdraw her appeal and move forward today.
We'll go ahead and withdraw the application. Do we have to make, is there a matter of the vacating or?
Leave it to Todd. I don't think so, but you can leave it to Todd.
No, nothing needs, no. You guys administrative will be taken off the agenda.
All right, so we'll remove it from the agenda. Thank you for your time today.
Thank you.
Our next agenda item will be 7A, and this is for the rehearing for Darlene Hess. Darlene Hess, if you are here, if you could please come forward.
Yeah.
All right, hi, good morning. Okay, if I could have you both state your full name and titles for the record.
Yes. She's an emerging store manager at a Walgreens. I'm Melissa Shake. I'm just here for moral support and I asked me to represent Walgreens.
I'm going to swear you both in. Join me raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
Okay, great, thank you. I will turn it over to Mr. Cant.
I think before you did, she contacted me, so Brett will do his point, but this was an item that you had at the last board meeting. You made some comments. Darlene saw, listened to that. She contacted me afterwards. Melissa was helping her. I think her long-term goal is to move up and through Walgreens, and her tech license is something that she needs. She'll probably say that today. So I did grant the rehearing. So you have the items in the board book at 7A, and then you're basically just rehearing the whole case, and I'll turn it over to Brett.
Mr. Cant.
So this is Brett Cant. For the record, I prosecuted this matter on behalf of the state. It's case number 24-460 PTS. And yes, the respondent, Darlene Hess, PTT, certificate of registration number PT 27744. Just for the record, the findings of fact, conclusions of law, and order that you entered in this case at the last board meeting appears beginning on page 9228 of the board book. Ms. Hess's request for a rehearing in the form of an email to the board begins on page 9234 of the board book. The original charging document it begins on page 9235 of the board book. There's also some relevant documents in the board book in the form of the evidence against Ms. Hess, excuse me, not the evidence, the original application for registration and the annual renewals, in which she omitted certain information that was required to be disclosed. Those applications begin on page 9244 of the board book, and then Ms. Hess's criminal history, which she obtained from Las Vegas Metro and provided to the board, begins on page 9261 of the board book. So the original charges were that the respondent had an extensive criminal history of arrests and convictions, and she failed to disclose that criminal history on her original 2014 application for registration as a pharmaceutical technician in training. She was issued her certificate of registration, and then she subsequently failed to disclose that criminal history on all the subsequent biennial renewal applications. This was originally noticed for hearing at your March board meeting. Ms. Hess did not respond to the charges or communicate with the board in any way, so I was prepared to go with the default that morning. Then Ms. Hess appeared, and so in order to accord her all due process and fairness, we agreed to continue the hearing to the June board meeting. And then at the June board meeting, when you called this item, Ms. Hess failed to appear. So we did proceed with the default hearing, and you entered the order that's in the record, which include a revocation, and you also assessed attorney's fees and costs that were recoverable and had been incurred in the action of approximately, let's see, $1,268.54. And then once again, subsequent to that, she then sent in her request for a rehearing, and that's once again on page 9234. And she indicates there that she was present that day, but then she left. So this is essentially a third instance where you're granting her consideration of her matter. So that's just the background on this.
Ms. Hess, did you want to make any comments?
So, I appreciate your time, in granting me this hearing. In my initial application, it had already been 10 years previous that those charges, that I received those charges, and I was not aware of the process. And so I thought that I didn't have to put that on my application. And then when I got my tech and training license, I don't know, felt kind of thinking that maybe, yeah, it had been enough time. I mean, those charges came in like 20 years ago plus. I have been working for Walgreens for 21 years now. And I am an emerging store manager. I do need a pharmacy technician license to become a store manager, and this is what I have been working towards for the past 20 years.
Yeah, I'll try to help you a little bit. You came that day, you talked to me, you came that day, but you were frightened or something happened.
Yeah, so the first time I came and I guess we weren't ready or whatever. And so I was told that I had to come back. On the second time I came in and I like sat right there by Melissa with Walgreens shirt. And then I just got, I got scared and so I left. And I didn't, I don't know. I just got scared and I left. And so
You thought you might have been arrested. You thought you might be arrested, but you weren't gonna get arrested, but you thought you might have been. You told.
Yeah,
me,
there were
so.
a lot, fines, to be arrested and all this stuff, and it kind of scared me, so I left.
Okay.
Ms. Hess, you went through it and I think I didn't hear all of it, but what was your reason for not including the disclosures in all of your applications and subsequent applications?
So when I first applied, it had already been 10 years past. And I wasn't aware that I needed to, and so I thought maybe enough time had passed and that I don't know. It was my mistake.
So I think that's our opening statement. We'll go to Brett to kind of present what evidence he wants to present, and then you'll have another opportunity to talk later, okay? If you have something. I know you did in the other case of the.
Yes. If you're looking for any sort of a recommendation.
I'm probably not ready for that. I think I guess you're not denying, his case is that this happened. You're not denying that you didn't do it, that he has to prove that you did it, but you're saying you did it, right? So that there's.
Okay, once again, she provided her own criminal history. It's in the record. So you've got the applications that don't disclose it. You've got the record itself. And so beyond the fact that she's attested on the record that she didn't disclose it, you've got the evidentiary record as well. So at this point in time, I think the charges are proven. You've already entered, this is a rehearing of a order you've already entered. So the issue, I think, is whether you're inclined to amend the order and stay the revocation to allow the respondent to practice. That's your prerogative.
And is there any other evidence that it's okay, you're fine. We'll go slow. Is there any other evidence you want to present to the board? They may ask you some questions I think you've given us your criminal record. You've said that this happened. I think Melissa's up there to say that you're a good person. So you have like a character witness with you. I'll turn it to the board for any questions.
It looks like in the board book, we have additional documentation that you provided, Ms. Hess, in terms of your any criminal records. Is that correct? Did you submit those?
Yeah, I believe it was requested.
Yes.
Am I able to ask questions at this point?
You are.
Okay. So
But-
Miss Hess, hi, I'm Adam Porter. So at your hearing the last time around, I had made some comments that I felt like it was unfortunate that you weren't here to tell your side of the story. Within your last renewal application, you indicated some circumstances as to why some of that criminal activity was happening. It sounds like you indicated that you were being trafficked by a boyfriend at the time?
Yes.
Okay. I think the concern specifically is that there was some convictions related to possession of narcotic paraphernalia. Were you using drugs at that time?
Yeah. Honestly, yes.
Okay. When's the last time you used drugs?
Over 20 years, like 23 years, 24 years. It's that person no longer exists.
And then when you had your license, did you work some time in the pharmacy?
Yeah, I've been working. So when I became a shift lead at Walgreens, there were times where they would call for an IC3. They needed help in the pharmacy. So I had to apply for a tech and training license so that I could go back there and help, in the drive-through, the checkout window.
Yeah. And I think the concern, not for the board, for the staff though, is that you have access to controlled substances, free access back there. And so during the time that you were there, you had access to controlled substances and you didn't feel the need to take them or sell them or do any of that. So, but you had access to them, right? So you were there. And then how much time have you think you've spent in the farm? You have my board book, so I can't look. So how long have you been working in the pharmacy? How many years? Okay, so 12 years you've been there, you've had access and you haven't taken it. Okay, no. I think that has some meaning, so.
And the last 2 years, so the last time I was actually working in the pharmacy was in 2023, the end of 2023. I since transferred to Fremont Street, Walgreens.
There's no pharmacy.
Pharmacy right now.
It's a busy store though, yeah.
Yes, it is.
Great. And so at this point in time, you have fully disclosed all of your background criminal history. Is that correct?
Yes.
And so for the last 20 some years, you have not gotten into any sort of trouble.
Yes. Thank you.
Good for you.
Thank you.
All right. I think seeing that Ms. Hess has taken full accountability, she is not denying any of the charges. She's accepting it. She's accepting that the factual allegations are true. And so I think procedurally, if we wanted to revisit the previous stipulated order, how might be the best way we can do that, Mr. Weiss?
This is Senior Dag Todd Weiss for the record. This is a re-hearing, so whatever disciplinary order you give now replaces the old one.
Okay.
If you want to, you can always just say we're not saying, same order we gave before, but you're free to make whatever disciplinary order you would like at this point. It doesn't have to be at all like previously issued.
Can we just modify the certain components, or do we have to go through the findings of fact, conclusions of law?
We can, the findings, fact, conclusions of law from the previous hearing are all on the record. You can just give, the attorneys will draft the order. So you can just give them direction that you're gonna stay with the same findings of fact, conclusions of law, and just amend the disciplinary order part if that's what the board is wanting to do.
Okay, great, thank you.
One other disclosure. Sorry, Jade, go ahead. Sorry.
Sorry, I just
motion.
I wasn't going to make a motion. It's too early for that, but I had to find a way to kind of slip on in there. I wanted to disclose that I am now an employee of Walgreens. However, I feel like I can participate fairly and without bias.
Okay, we'll note that for the record. All right, thank you, Mr. Cobo.
My disclosure was I did take the liberty. I didn't post any of this because it would have affected her jobs. Talking to her could have affected her job status. So we didn't contact the national database. I didn't post this on the website. I left her because there was an appeal. I left her as an active license, just so that you know. So.
Board members, any additional questions for Ms. Hess?
President Park?
Yes.
Brett Camp for the record. I just, once again, one possible path is to stay the revocation. It's already in place and place her on probation for a period of time. And you may also want to revisit the attorney's fees and costs and when they're due, because they were due and payable earlier this month. And I think the respondent would need more time to be able to pay those fees and costs.
Do you have updated fees and costs for this part of the hearing, or you just want to go with the other ones, or, yeah? you-
Can't for the record, no, I did not calculate additional fees and costs, so they were fairly extensive anyhow in the first instance, because it took a while to research each
That's
and
fine.
every arrest and conviction and try to ascertain whether it was accurate or not.
Problem. Thanks.
Um,
Madam President,
yes,
Ms. Hess, first, I want to commend you for turning your life around. I think that was very, very good. And like our executive secretary said, that you spent 12 years around the drugs and still didn't get any problem. My question is, you're working for Walgreens as a what right now? What do you do for them?
I'm an emerging assistant store manager.
Okay, and you need this tech and training license, is that what it's called?
I need a tech and training license to retain my assistant store manager position. However, I'm trying to get to store manager, and to be a store manager with Walgreens, you need a technician license.
It's a requirement of Walgreens employment, not the state, but the Walgreens
Right.
is required.
Okay, and I take it that Walgreens kept you, promoted you through the ranks, knowing what you just disclosed to us, right?
Yeah,
They still
yes.
took the chance with you and it's
Uh-huh.
worked out for them. They were right, right? So that's
Yes.
it. Okay, it's interesting that this case came before us this morning because we have here students sitting that are studying pharmacy, and they have to see the importance of their backgrounds, because ordinarily, if someone comes before us for a pharmacist license with a background that's involved in narcotics and other felonies, the answer would be no. And so, but this is a little different, and it's got some extenuating circumstances, but the students should take note of how important this is to this board and to the staff about a person's life and background. So this is very important. It's a career that holds people's lives in the balance
Yes.
as well as their own. So again, I commend you
Thank you.
for what you did.
Yeah, I guess just to add on that, thank you, Mr. Tomaso, Adam Port for the record. I would just agree. I would say for the students in the audience, it's critically important that you are honest with the board. I think that there's always an opportunity to tell your story. You know, that this is clearly an example of somebody who has turned their life around. So.
all right, board members, any additional questions at this time? All right, so we have some suggestions or recommendations from Mr. Cant in terms of modifying the previous stipulation and order. So if we go to page 9231, that's the previous order that was signed from the last board meeting. I think if we modify number 1 with a stayed revocation, and then number 2 would not apply because it says respondent may not petition for reinstatement. So we can strike number 2. Number 3 is taking place today, which is that the respondent must appear before the board. And then there's the fines.
So strike 3 too then.
Strike 3 as well, yes.
Just to clarify, yeah, if you're going to stay the revocation, then you need to place her on probation for a period of time. And I'd leave that to you. 2 years, 3 years, 5 years, whatever you think is appropriate. And then secondly, just the due date for the attorney's fees and costs. I think you maybe want to give, maybe you want to give her a year. I don't know.
So I would say probationary period for at least 1 year. And then for the due date, Ms. Hess, your fines amount to $1,261.84. Is that something you can pay within 1 month, 6 months, a year?
A year?
And so we will modify the payable date to 1 year from today, when it becomes effective. That's my suggestion. So board members, any other comments or any other recommendations?
Why don't we just make that a motion? What you just said, this.
Okay, I could certainly make that a motion. All right, this is Helen Park. I move that we modify the previous stipulation and order for Miss Darlene Hess. The modifications will be for number 1, that the revocation is stayed and the respondent will be placed on probation for a period of 1 year. Number 2 and number 3 will be stricken from the record. And number 4, the amounts will be due and payable 1 year from this date.
Second.
So there's a motion by Helen Park, second by Dick Tomaso. Any further discussion?
Camp for the record, and just to make clear that that's all effective immediately.
Effective immediately. Yes, thank you. Okay, any further discussion? All right, all those in favor?
Aye.
Aye.
Any, no, Ms. Jacobo, I thought you were recusing yourself.
No, she stayed on. She just disclosed. She didn't recuse.
Oh, that she's fairly and unbiased. Okay, gotcha. Okay. All right, any opposed? All right, that motion passes. All right, well, we thank you for your time today.
Thank you all so much.
Thanks.
Thanks.
Okay, we'll move on to agenda item 5G and 5H, and that's for Ibrahim Fakhuri and Nirav Gandhi. So Dr. Fakhuri and Dr. Gandhi, if you are here or if your representatives are here, please come forward.
We are here. We are here. Our representation should be there.
Okay. All right, so we'll start with your representation in the room. If you could identify yourself, please.
Yes, Maria, is this on? Maria Newtile for Dr. Maria and Dr. Gandhi.
And then for the doctors, if you can state your full names for the record, and then I'll swear you both in.
My name is Dr. Nirav Sharad Gandhi, Gandhi.
Thank you.
My name is Abraham Fakhuri. Last name F as in Foxtrot, Akhouri.
Okay, great. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Yes.
Great. And with that, I'll turn it over to Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This is for agenda items 5G and 5H. They can be found on pages 8942 and 8965 of your board books. This is for case numbers 25-274-CS-A-S and case number 25-274-CS-B-S. The respondents are Dr. Ibrahim Fakhuri, Certificate of Registration CS 19540, and Dr. Nirav Gandhi, Certificate of Registration CS 14653. In our accusation, we allege that while working at Nevada Family Care and Wellness, Dr. Fakhuri and Dr. Gandhi administered retatrutide and cagrilintide drugs to patients, both of which are not approved by the FDA. Furthermore, Dr. Fakhuri dispensed dangerous drugs without a license and properly stored medications, failed to maintain and produce accurate records to board staff upon request, engaged in unprofessional conduct by purchasing from unlicensed manufacturers, and permitted unlicensed distribution of drugs. In the accusation, we had 6 counts for against Dr. Fakhuri. Count 1, dispensing without a license. Count 2, violation of state law for improper storage of medications. Count 3, failure to maintain records. Count 4 was against both doctors for possessing, selling, or furnishing drugs not approved in the United States. And for Dr. Fakhuri, count 5, unprofessional conduct for acquiring drugs from an unlicensed retailer, and count 6, unprofessional conduct for permitting unlicensed distribution. We have two stipulations to present to you today. They can be found on page 8957 of your board book and page 8980 of the board book. For both doctors, their certificate of registrations, their controlled substances licenses are suspended. However, the suspension is stayed for a period of 1 year from the effective date of this order. Dr. Fakori has agreed to pay an administrative fine of $10,000 payable within 30 days of the date of this order. Dr. Gandhi has agreed to pay an administrative fine of $5,000 payable within 30 days of this order. And each doctor will pay $1,000 in attorney's fees and costs payable within 30 days of this order. So we would like to present the stipulation to the board today for approval with an effective date of today, July 15th, 2026.
Thank you. And then I'll turn it over to Ms. Newtile.
Thank you. I was not counsel of record over a year ago when the investigation first began, but I would like to note that counsel at that time did have Dr. Fakori admit all allegations at that time. He was fully cooperative, and I understand ignorance of the law is no excuse, but as you probably hear so many times, he really did not know certain provisions of the law. But once again, that is no excuse. So he did admit as to the procuring and distributing the drugs at the time. Once again, Dr. Gandhi, who also works there, while he didn't procure them, he did provide for his patients. So once they realized, they fully stopped as soon as they were told you cannot do that. So they stopped immediately. They want to put this behind them. I do appreciate Ms. Tucker permitting us to go right to a stipulation as opposed to having to spend more legal fees on filing a response because they admitted. So what would we say in a response? So we would request that you accept the stipulations.
So this is Helen Park. The question I have is just for the doctors in terms of administering the retatrutide. At the time, were you aware that it was not FDA approved, or did you know or not know? I'm curious as just how it got to that point.
You should answer first.
Well, I'd like to respond. Basically what happened was patients were requesting it. And so we sourced it, or I should say I did. Dr. Gandhi was not involved. Sourced it online for specific patients. It wasn't something that we kept in stock in the office and we just had it to give to patients. It was specific patients who asked for it. I learned after the vendor we purchased it from, probably within 3 months, that it was still, I believe, in stage 4 or stage 3 clinical trials. I don't remember which one. And so then that was when we decided that was, something we didn't want to do. But at that time, the representatives for the board had come into the office, and that's when I spoke to them. And that's when all this happened.
Okay, so at that time, you weren't aware that it wasn't FDA approved?
Well, I thought it was like all other peptides, free to purchase online anywhere else. It's labeled as a peptide, so I just assumed it was okay. And that's when I read that it could not be. It was still in clinical trials. I just didn't know how these places were basically getting a hold of it to be able to resell it.
Okay, so then now, how has your practice changed?
Well, we've removed all this stuff from the office to let patients know that we don't carry it anymore, and recommending to them not to purchase it online until the FDA approves it for sale. So until it's out of clinical trial.
Okay, and I believe the wholesalers that you worked with were not licensed in Nevada.
They were in Nevada and then they went to Florida, is what I learned afterwards. But either way, they were not. They couldn't sell retatrutide anyhow.
I guess what I was trying to get to is that you are now only going to work with licensed wholesalers, that you're going to make sure that your future purchases are with drugs and from wholesalers who are licensed and the drugs are FDA approved.
Yes. Now use local compound pharmacies for whatever they're able to carry, and that's where we're ordering from, if we do anything at all.
Okay.
And this is just for the peptides, I guess and I apologize, what you call dangerous substances. I did not know ibuprofen was a dangerous substance since a 13-year-old can purchase it from a drugstore. Those were actually purchased from a major distributor, which is like McKesson online. So I just assumed that if we could purchase those, then we could just redistribute them to patients who need them.
Okay, but not anymore.
No, we can't without a dispensing license. I know that.
Very good. All right, board members, any additional questions?
Just I'm curious, Counselor, has this case been heard by the medical board?
Not yet. I've apprised my clients that we fully expect it to be once you have a decision here. They're aware of that. I mean, we always have discipline from each boards. There's so many of them. My only hope with the medical board is that they would not wait 4 or 5 years, because then it's like facts all over again, and they've been known to do that in some cases. So once this goes, we will actually report it, but even though you report it, it may take them, unfortunately, too long to respond. But we fully expect discipline there.
Thank you.
So I am comfortable with the stipulations as presented.
Adam Porth, for the record, I would agree, Madam President. My biggest questions were the same ones that you had for the position. So I would move that we approve the stipulation orders for Dr. Fakuri and Dr. Gandhi as presented by board staff.
Crystal Freitas, second.
Okay, we have a motion by Mr. Porath, a second by Ms. Freitas. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, the motion passes. All right, we thank you all for your time today.
Thank you.
Thank you.
Thanks. Okay, next I'll call for agenda item 5J and 5K. That's for Total Infusion Care Inc. And then also for Mohammed Ordemeyer. So please come forward. All right, hi, good morning.
Madam President, board members.
Mr. Cillian, it looks like we have some folks online as well. Are they part of this item?
Yes, it looks like Morgan Haber, who's general counsel, and I think COO, I always get the title messed up.
That's okay, we'll
And then
do.
Kim Moore, who is senior vice president for pharmacy for Lux, both of them for Lux.
We will go around and do full introductions. So if you could state your full name, titles for the records, and then for the non-attorneys, I will swear all of you in at the same time.
Going for the respondents, both respondents.
I'm Mohammed Hussein Moore, the former pharmacy manager.
Great.
Jonathan Chan, the new pharmacy manager.
Justin Chan, I think I know you from Roseman University, is that correct? Okay, I thought you looked familiar. For the record, I am familiar with Jonathan Chan, but I feel like I could participate in this matter fairly and unbiased. Okay, all right, and then we'll move online to Kimberly Moore. Is your line unmuted?
Yes, but it's not. Can you unmute me?
Yes, we could hear you now.
Oh, you can.
Yes.
Good morning. My name is Kimberly Moore. I am, as stated before, I'm the Senior Vice President of Pharmacy Operations for Lux Infusion.
Great, thank you. And then Morgan Harbor.
Hi, yes, Morgan Harbor. I'm Chief Administrative Officer and General Counsel for Lux Infusion.
Right, so for our 3 non-attorneys, I'm going to swear you in together. I just need a verbal affirmation from each of you. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Yes.
Okay, great. Great.
Just a foundational point. Lux, I think they have is it a different name or something? So can you just?
I can give a quick summary. Yes.
Just so we make sure on the record, we have the right people here. That's all.
Absolutely.
Yep.
Is that this case is about Total Infusion Care, which that was the name of the company or the pharmacy up through December 2025, January 2026. But they were purchased by Biomatrix on November 7th or thereabouts of 2025. Biomatrix is now Lux. So that's just that. So when we refer to Lux, it's synonymous with Total Infusion Care. We actually, just by way of reminder, we were here in April for a change of ownership for this. And you all asked a lot of questions about it. And if it doesn't ring a bell now, it probably will as we go through it, because Ms. Haber and Ms. Moore and Mr. Chan, Mr. Portman, we're all here then. And so the same facts that underlie this proposed stipulation were discussed then. There was some hint that there was an investigation that was going to come before you. It has now come before you. Does that help?
Yeah, thanks, Bill. I appreciate that. Just want to make sure for the record, we have the right people here. Thank you.
So with that, I will turn it over to Ms. Tucker.
Thank you, Madam President. Laura Tucker for the record. This is for agenda items 5J and 5K, which can be found on pages 8999 and 9019 of the board book. This is for case numbers 25-501-PH-S and case number 25-501-RPH-S. This is for respondents Total Infusion Care, license number PH02936, and Mohammed Portmar, certificate of registration number 13759. In our accusation, we allege that during inspection, Total Infusion Care, a home infusion pharmacy that exclusively performs sterile compounding under managing pharmacist Mr. Portmar, had numerous violations and was not in compliance with state laws and regulations relating to the operation of the pharmacy. We charged 3 counts in this case. Count 1 was unprofessional conduct against Mr. Portmar. Count 2 was failing to maintain records, and count 3 for Total Infusion Care was pharmacy responsibility. We have a joint stipulation to propose to you today, which can be found on page 9011 of the board book. The terms are that each respondent shall pay an administrative fine of $5,000 payable within 30 days of the date of this order. Each respondent shall also pay $1,000 in attorney's fees and costs payable within 30 days of the date of this order. And board inspectors shall conduct quarterly inspections of Total Infusion Care at the pharmacy's cost. We present this stipulation to the board today for approval with an effective date of today, July 2026. And I believe Mr. Stilling would like to provide a few details about corrective action that the pharmacy has taken.
Mr. Stilling.
Yes, thank you. And we are in agreement with the stipulation as well. As I said, maybe this is not familiar that there was an inspection in December 2025 by Mr. Dodge. They came in and found some deficiencies in that the new 797 was not being followed. The new owner rushed into action along with Mr. Portermeyer and I responded to Mr. Dodge to everything he asked for in a timely fashion. I discussed that back in April. I think Mr. Dodge agreed that they did respond with what he requested to alleviate his concerns at the time. And then we've included in the stipulation the paragraph 8. I don't think we need to go through all these, and I'm not the expert in this area, but we've indicated the changes that did take place after that. Mr. Portermeyer pleaded 34 hours, 34.5 hours of critical point training on the new 797 standards. I think he did that within a week or two of the inspection. Then Biomatrix, now Lux, hired a consultant who came in the day after Christmas to make sure things were in order, worked there for a month on site. And then the other steps, I don't know that I need to read them, but they increase and so I'll presume the board read them, otherwise I can read them into the record, but it was an extensive.
Have it in front of
set.
us.
I don't want to take your time unnecessarily. And if you have any questions about this, Ms. Moore is the person who can articulate that as she did again back in April. So we believe the stipulation is a good one. The pharmacy is up to par now. We are waiting for an inspection. In fact, when you all granted the change of ownership, it was contingent on obtaining an inspection, which hasn't occurred yet. They're just waiting for that. I think looking forward to it, right? But and in fact, they would like to do it so that can all be finalized. So.
Glad to hear that. Okay, board members, any questions for Total Infusion Care or Lux or for Mr. Portimore?
Adam Porth for the record. I don't have any questions. I appreciated seeing the mitigating circumstances within the stipulation. I think that helps. I would move that we approve the stipulation in order for Total Infusion Care Inc. and Mohammed Portamayor as outlined by board staff.
Okay, we have a motion. Do we have a second?
Crystal Freitas, second.
Okay, motion by Mr. Porath, second by Ms. Freitas. Any further discussion? So I agree. I like seeing all the mitigating circumstances. That was helpful to see. So I appreciate that, and I appreciate the fact that action was taken very quickly afterwards. So that has been noted. All right. With that, all those in favor?
Aye.
Aye. Any opposed? Okay, the motion passes. We thank you all for your time today.
Thank you too for your time.
We're going to take a quick break and we'll be back just momentarily. We will continue with our Board of Pharmacy meeting. Our next agenda item is 5D for David McCleave. So David McCleave, if you are here or if your representative is here, if you could please come forward or raise your hand on Zoom. We have anyone online?
We're not seeing him, we haven't had communication with them, so not surprised by that, but we're not seeing him.
Additional call for David McCleave. And then if not, Mr. Cant, are you ready to proceed?
Brett Camp for the record, prosecuting this case on behalf of the state. I'm prepared to move with the default hearing.
He does not appear to be in person or online, so we'll go ahead with the default hearing.
So this is case number 26-125 CSS, named respondent David Cale McCleave, certificate of registration number CS 22331. Charges begin on page 8852 of the board book. The respondent failed to file an answer and notice of defense. Beginning on page 8861 of the board book, you will see an order from the Nevada State Board of Medical Examiners revoking the respondent's license number PA 1526 to practice medicine for cause. And then on page 8893 of the board book, you will see a notice of suspension that was issued by this board notifying the respondent that with the revocation of his medical board license, it operated as immediate suspension of certificate of registration number CS 22331 with this board. So with that, I would proceed first to ask that evidence be entered into the record in the form of declarations from board staff that the respondent was probably properly served with the charges in the case and notice of this hearing today.
We will admit this as Exhibit 1.
And with that, I would proceed to ask that the board find that it has jurisdiction and make findings of fact consistent with paragraphs 1 through 3 of the accusation.
The declaration of Aaron Miller will be Exhibit A, and we'll admit the declaration of Gisette Benericone as Exhibit B.
I'm sorry. Yeah, there are 2 exhibits there for declarations of service. And with that, I'm sorry, once again, I would ask that the board find that it has jurisdiction and make findings of fact consistent with paragraphs 1 through 3 of the accusation.
J. Jacobo, so moved.
Second. Okay, we have a motion by Ms. Jacobo, a second by Ms. Taylor. Any further discussion? All those in favor?
Aye.
Any opposed? Okay, that motion passes.
Next, I'd ask that the board make conclusions of law consistent with paragraphs 4 through 11 of the accusation and find respondent guilty on all 3 counts.
J. Jacobo, so moved.
Second. Okay, so motion by Ms. Jacobo, second by Ms. Taylor. Any further discussion? Okay, all those in favor? Aye. Any opposed? Okay, that motion carries.
I would also ask that the board make an additional finding that the respondent was notified of this hearing and served with the charges in conformance with Nevada law.
So moved.
Second.
Okay, motion by Ms. Jacobo, second by Mr. Porath. Any further discussion? All right, all those in favor?
Aye.
Any opposed? Okay, that motion passes.
Next, I am going to ask for revocation, but before that, we're going to pass out a memorandum of attorney's fees and costs that were occurred in investigating and prosecuting this matter. Ask that those be admitted into the record as Exhibit 3 or C or whatever. I do want to note that the total on the memorandum is incorrect. On page 2, the total attorney's fees and recoverable costs is actually $331.65.
This will be so admitted as Exhibit C with the correction of the total attorney's fees and recoverable costs as $331.65.
Yes. And finally, I would ask that the board enter an order revoking the respondent's certificate of registration number CS 22331 and provide for the statutory minimum period of 1 year to petition for reinstatement. And also award the recovery of attorney's fees and costs in the amount of $331.65 on the basis that they were reasonable, necessary, actually incurred, and also that the order be effective immediately.
So moved.
Second. Motion by Ms. Jacobo, second by Ms. Taylor. Any further discussion? Okay, all those in favor?
Aye.
Any opposed? Okay, that motion passes. Does that conclude? All right, that concludes that matter, and we will move on to our next agenda item.
Yeah, Madam President, you have one more appeal of a cite and fine, and we're in communication with them. There was a timing issue about when we were going to start trying to fit the rest of the meeting, so everybody's behaving well. But we are prepared to take some items from tomorrow. So these are not discipline for the board. These are applications, and you'll be reviewing those applications.
So for the matter that we have scheduled today, will the attorney be in person or online?
We think in person, but we'll probably do this one and then take one more break and see where we are, because I don't have anything else before lunch for you. We haven't moved anybody over. The staff's talking about moving and saving you some time tomorrow, but I think if you proceed with this one, then we'll take a break and then I'll have a clearer view of it.
Sounds good. With that, we'll move on to agenda item 9A for Dignity Health Rehabilitation Hospital. So we have representatives here or online. If you could please come forward or raise your hand on Zoom or let us know through the chat function.
Hello. I'm outside counsel for the applicant in this matter. And I'm joined as well by Lindsay Boswell, who's an associate general counsel at Select Medical, as well as Daniel King. Should be on as well. I don't see his video popping up, but he is the senior director of pharmacy at Dignity Health Rehabilitation Hospital.
Yeah, so can you do me a favor, just move a little bit closer to your microphone? We can hear you, but you sound a little bit, so if you can connect with that a little bit better, we'll be able to hear you.
Sure, I will also increase the volume of my voice. Is that any better?
Yes, I had missed your name in the beginning. I apologize.
Sure, my name is Ariel Lusardi.
Okay, great. And then both you and Ms. Boswell are serving as counsel today?
That's correct.
Great. All right, and then it looks like we have Mr. Daniel Kim who has joined. If Mr. Kim, if you could state your full name for the record.
My name is Daniel Kim.
Okay, Mr. Kim, you are also a bit hard for us to hear. If you could speak closer to your mic.
Just a second, repositioning my phone here.
Okay, great.
That better?
I think so. And then if you could just speak louder in general, that might help. I'm going to swear you in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Okay, great. Thank you so much. And with that, I'll turn it over to Mr. Kuykendall.
Thank you, Madam President. We have a change in ownership application for Dignity Health Rehabilitation Hospital, item 9A, and begins on page 9318 in the board book. This is an institutional pharmacy in Henderson that also does sterile compounding. They had their last annual inspection in April. The inspection was satisfactory with no deficiencies identified. My first question for you guys, and for anyone can answer, but can you please explain the change of ownership that took place?
Yes. So as you noted, this relates to Dignity Select Nevada LLC doing business as Dignity Health Rehabilitation Hospital. That entity is a joint venture between Select Nevada Holdings, Inc., which is the 51% majority member, and Dignity Health, which owns the remaining 49% interest. Select Nevada Holdings is a subsidiary of Select Medical Corporation, which is owned by Select Medical Holdings Corporation. Select Medical Holdings Corporation has historically been a publicly traded company with its shares listed on the New York Stock Exchange. On July 1st, Select Medical Holdings Corporation completed a transaction through which it became a privately held company. And this transaction involved the acquisition of all of the outstanding shares of Select Medical Holdings Corporation by a consortium of people led by Robert Ortenzio, the executive chairman and co-founder and director of Select Medical, Martin Jackson, the senior executive vice president of strategic finance and operations of Select Medical, and Select Medical's multi-time capital partner, Welsh Carson, Anderson and Stowe. And so as a result of the transaction, Select Medical Holdings Corporation became a privately held company that's indirectly owned by that consortium of individuals and entities that I just mentioned. So, just to kind of set the table here, this transaction ultimately occurred very high up the corporate chain. 10 levels above the licensed entity. And so there will be no impact on the actual operations of the licensee here. Everything will continue as status quo at the licensed entity. This was a corporate level ownership change.
All right, thank you for that explanation. And then just to specify, will there be or has there been any staffing changes specifically with this ownership change?
No.
And then any changes to policies or procedures with this ownership change?
No.
And then I just want to reiterate, there's no service changes with this ownership change?
That's correct.
All right, well, thank you very much. I'll hand it back over to the board.
Okay, so with that, I don't have any further questions with the ownership change. It does sound like it was high up and there are no impactful changes. So I'd feel comfortable moving with the change of ownership.
Crystal Freitas, for the record, I agree with you. It's pretty straightforward. So I move to approve ownership change for Dignity Select Medical.
Ms. Taylor, second.
Oh, sorry, it's Dignity Select Nevada. Sorry.
Okay, so we have a motion by Ms. Freitas, a second by Ms. Taylor. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, that motion passes. Your ownership change has been approved. We thank you for your time today.
Great. Thank you so much.
Thank you.
Thank you.
Hey, Madam President, we can migrate into the Senior General Counsel and the council report. I'll do mine first to give you time to prepare yourself. We can get those out of the way if you want. So there's, as every year this time, there's no fiscal report because we're going through the closing of the books for the state fiscal year that ended in June 30th. So we'll have an update of that at the next meeting. I can tell you that yesterday I attended the Board of Examiners meeting and we did get approval for statutorily, we have to have a CPA firm outside of us do an annual audit of us. And so we're preparing for that audit as we speak. And that did get approved for 2 more years. So it's the same company we've used for the last couple. They changed names because their ownership changed, but that's happened. Temporary licenses are in your board book, addresses, meetings with other regulatory boards. Investigational, we just recently, I think Amy went to the staff for the investigations of the medical board and had a meeting with them and just kind of making sure that we're working well together. Nothing to report in particular because they're investigations, but I know Amy was new and went to that to that meeting. So they did that. I do want to make a note that Kathy Denauer, who was is or was the executive of the the nursing board, has retired. She's retiring this month. I've been talking to Kathy a little bit. She had a medical issue that forced her retirement. So it was great to work with her over the years. I continue to talk to the staff there, and they'll probably be getting a new executive, and then the plan will be to meet them and work with them. They have some new staff coming on board. So certainly you've spent some time with the medical board and the nursing board working through Medi-Spas and what those look like, and the legislative actions that may come in the next session. So we're beginning to do those kinds of things. The rest of the reports are there. I'll go to the legislative update. As we have not heard back yet, but Mike's working on it about our proposed bills. They would ultimately come in front of you, but I had to put a holding spot for the governor's bills. So we had 3 bills that I turned in. One was related to the Medi-Spa, continued to work with the health department. And then 2 were related to fees and stuff related to federal grants, and then just a fee to address some of the financial shortcomings. Don't know if we're going to continue with that. I know Adam did work with us on this. The feds did have a little bit more money in their DOG grant. They offered to us. We applied for that. I did turn that budget in. The budget items that we're going to use on that is some attorney costs related to Brett, related to controlled substances, and then Kanan, our biostatistician. We'll probably have him do a little bit more with the PMP than we were doing to utilize those grant funds. And then we tentatively budgeted another investigator through the grant, but we'll just see how that kind of pans out. So, and then we were able to do some hard costs such as rent and other supplies that the board typically would eat that amount of money, but we're allowed to put in the grant. There was never enough room in the grant to cover rent and stuff like that, but we've redone it. And that budget was turned in but not approved yet. So we'll just work through those. So that's what the finances look like for the board now. And I'll go ahead and see if there's anything for our senior general counsel, Laura Tucker.
Thank you, Laura Tucker for the record. Our big announcement is that we have a new attorney, Amy Steelman, is joining our legal department. I've known Amy for probably 10 years now, and she comes to us most recently from working at Dieter. And Amy, I don't know if you would like to introduce yourself. I'm putting you on the spot now.
Hi, Amy Steelman for the record. Yes, as Laura said, I'm very happy to be joining the Board of Pharmacy. I did come most recently from the Department of Employment Training and Rehabilitation. I also spent a number of years at the Attorney General's office, also Carson City DA's office, so I have a diverse background. I did my law school at the University of Southern California, my undergrad at the University of Chicago, and yeah, I'm just really happy to be a part of this team, and I look forward to working with everyone.
Great, welcome, Amy. We look forward to working with you as well. Thank you.
All right, Madam President, I would suggest that you just recess because we might have one more item before lunch. So if
for that, I just wanted to see if Ms. Tucker was complete with her report.
I just had one update, sorry, Laura Tucker for the record. Just the only outstanding petition for judicial review right now is the Brooks case, and Brett, everything says that everything's been submitted and we're just waiting on the court for the next steps.
Okay, very good. Thank you for your report. I'm sorry, Mr. Weiss. And then
oh, I'm sorry about that. I think that as opposed to breaking for lunch, I would just recess for right now, and we'll just see if we're waiting for one attorney to either come on Zoom or in person, and then we can deal with that potentially before lunch. So I think that we could go back into meeting at any given time, but if you want to recess, and Todd's shaking his head yes, so it means I did well. So
we'll take a quick recess. Thank you. All right, we're back with our Board of Pharmacy meeting. At this time, we have one further agenda item scheduled, but we will continue that agenda item till after lunch. So for now, we're going to go ahead and break for lunch, and we'll be back at 1 p.m.
Madam President, Dave Weiss for the record. Just 12D has agreed to go after lunch if there's time. So that's a appearance, not a discipline. And the board staff will continue to work to see if there's others that would like to get done today. So we may have more after lunch for the public. Just what you're saying is correct. We have one more for sure.
Thank you, Ms. We are back with our Nevada State Board of Pharmacy meeting. We are moving to our next agenda item, which is agenda item 6B. And this is the appeal hearing for Kent Holtor. So hi, good afternoon.
Good afternoon. Shandon Alexander here on behalf of Dr. Holtor. Cardiac event that required him to go to the emergency room.
Sorry to hear that. Thank you for letting us know. And then you are accompanied by
my assistant, Angie Montgomery.
Angie Montgomery with Spartacus Law Firm.
Great, thank you. Okay, so I believe we have some preliminary Motions?
Yes.
Just for, and maybe, I mean, in light of your client, do we want to, are you asking for a continuance based on that? And they'll do whatever they're gonna do, but I just want for the record, sorry that happened. That's your decision, but we're not opposed to that. Obviously, that would affect the case, obviously, but that's for you. So I don't know, but that's really not in front of you because it's news to us today, so.
Correct. So we are asking for a continuance as a result of Dr. Holtorf's absence. We do have a number of pending motions. That would be up to the board if they want to hear those now or later. We have been in very positive discussions with board counsel. I believe we have the matter resolved moving forward, but I'm going to leave it up to the president to rule on the motion to continue and whether or not we want to hear any of the motions at this setting.
Yeah, time-wise, prosecution, right? What is your stance on that?
As far as obviously we'd have to continue the actual hearing because the respondent is not available. So we stipulate to continue the hearing.
Or that position on hearing the motions today or not?
You need a minute?
Yeah, we might get that.
Okay, well, you guys, yeah. Can you put us just in recess? Give it 5, sorry.
Recess. All right, we are back from our recess. And Ms. Tucker.
And thank you, Madam President. For the record, it sounds like we are in council's in agreement that we would just want to go ahead with the pre-hearing motions that were pending.
Okay, so for the matter of the continuance, since there's no objections on your end and due to the medical emergency, the continuance will be granted. Not so much for the other reasons previously stated in the for the continuance, but due to the medical emergency, we will go ahead and continue the hearing. But it sounds like we are in agreement that we want to go ahead with the preliminary motions.
Sure.
So Mr. Alexander, go ahead.
Just for clarification, as a point of order, I think it makes sense to start with because there's 2 motions to dismiss. Start with the first one.
And just Brett Camp for the record, let me know, I'm going to argue the motions on behalf of the state, even though Ms. Tucker is prosecuting this case. Just, that's why I'm up here.
Thank you, Mr. Kant.
1 second, I'll get some paperwork. The respondent's first motion to dismiss asks a singular question. Does the board's enabling statute give the power to fine Dr. Holtorf for his conduct? There are 3 independent answers, and each one is a no. First, the administrative penalty authority of a person that is not licensed by the board is fixed by NRS 639.2895. The 4 statutory predicates. And nearly every authority in the complaint falls outside of them. Second, the 2 predicates that could remain each require a dangerous drug or a prescription drug. And none of the peptides in question is either. Under the closed definition, the legislature wrote. Third, what the complaint actually describes, diagnosis, therapeutic relationship, medical necessity, on-site treatment, is the practice of medicine, which belongs to a different board under a different chapter. Any one of these require dismissal, but we'll take them in turn. Just very quickly as a point, a kind of a housekeeping point for the merits. In the opposition, the board argues that this motion is procedurally improper, that the statute provides only for a hearing, not for motion practice. Our position is that the objection has to be moot at this point. And so if board counsel is continuing to press that objection, we just note for the record that it lacks merit. Subject matter jurisdiction may be raised at any time, cannot be waived, cannot be conferred by the parties, or manufactured by an agency's failure to write a rule. A big part of our motion is regarding and encapsulating subject matter jurisdiction. On to the predicates. The board's penalty authority over an unlicensed person is capped at 4 predicates. Begin with the source of the board's authority over someone who holds no board license. That source is, again, NRS 639.2895. It says that if the board determines a person has violated subsection 1 of NRS 639.100, subsection 1 of NRS 639.2813, or NRS 639.284, or NRS 639.285, the board may issue a cease and desist order, issue a citation, and assess a fine of up to $5,000 for predicates. The legislature named them with no precision, and that list is exhaustive. So if we look at the operative complaint in this case, it actually cites more than 15 authorities. It cites chapters 454 criminal drug statutes, which is peculiar, whose penalties fall under NRS 639.300 and are recovered by the district attorney's office. Title 15, again, crimes against a person, which is NRS 200.820 and 200.840, prosecutable only by the Attorney General or the district attorney. The Federal Drug Supply Chain Security Act and its regulations, enforced by the FDA and the Department of Justice. None of those appears in NRS 639.2895. The board just does not have the authority to adjudicate those provisions against an unlicensed person in an administrative fine proceeding. Strip them away, and exactly 2 Nevada predicates remain. NRS 639.100 subsection 1 and NRS 639.285. This will attempt to demonstrate neither is satisfied. Everything else should be dismissed or stricken at the thresholds outside the board's enforcement authority. One of the big arguments is that peptides are not dangerous drugs. So counts 1 and 2 fail. Counts 1 and 2 rise or fall again on a single item, dangerous drug. Every chapter 454 statute they cite is triggered only by a dangerous drug. And dangerous drug is not a loose term or description. It's a closed statutory definition encapsulated in NRS 454.201. So let's look at what encapsulates a dangerous drug. A substance qualifies only if it is one of 3 things, and only 3. This list is exhaustive. 1, a drug the FDA has approved for general distribution that bears the legend RX only. 2, one of exactly 2 named substances, which is Gerovital H3 or Latril. Or 3, a drug that this board, by its own regulations, has found dangerous to public health or safety and made prescription only. So as to prong 1, none of the peptides at issue named in the complaint, namely MOTC, B21, BPC 157, TB4, Humanin ACE31, or CJC 1295 is FDA approved. And none bears the RX only legend because you cannot legend a drug that the FDA has never approved. These substances sit in a federal holding pattern. The FDA placed several of them in category 2 of its interim compounding list in 2023. the significant safety concern bracket, and then removed some of the peptides, BPC, MOTC, TB500 from that bucket in April 26, and removed CJC 1295 back in September 2024. But removal from category 2 didn't place any of them in category 1, the list of substances that may actually be compounded, and they are neither approved nor authorized. So the brief version of this is that the FDA briefly flagged them as safety concerns and dropped the flag when the nominations were withdrawn, but it never placed them back on the list that would authorize their use. So they remain unapproved substances in regulatory limbo. I believe there's a meeting on July 23rd to address some of these substances. As to prong 2, none of these substances is GeoVital or H3 or Latril. That prong is a relic, it has no application here. It's very easy to dismiss and can and should be quickly rejected. Prong 3, this is the prong that matters, and it is decisive. A substance becomes a dangerous drug under prong 3 only when this board, by regulation through rulemaking with public notice and comment under chapter 233B, has found it to be dangerous and made it prescription only. The complaint identifies no such regulation because there is none. This board has never promulgated a rule classifying a single one of these peptides, and the board cannot do so by adjudication in a singular contested case. What its own statute says must be done by rulemaking. If it could, the words pursuant to the board's regulations would not mean anything. All 3 prongs fail for every peptide. The one substance on the chart that does satisfy the prong is the vitamin B12. Prescription injectable, it is an RX only drug, and I can see that. But a B12 injection is one of the most routine lawful medical acts in Nevada, given every day by nurses, medical assistants, a number of medical spas pursuant to NRS 454.213. Its inclusion here proves the opposite of the board's case. It shows that the board knows exactly what real dangerous drugs look like, and not one of the peptides or any of the peptides is one. Because the dangerous drug predicate fails, every 454 statute in counts 1 and 2 falls within it. NRS 454.213, 217, 221, 316 through 21, 356, and 510, as does NRS 639.268, Section 1, subsection A, and NAC 639.757, which by their terms reach only dangerous drugs. Counts 1 and 2 should be dismissed in their entirety. 2 surviving predicates fail on their own terms. NRS 639.285, no sale of a prescription drug. NRS 639.285 forbids an unlicensed person to sell, display, or offer for sale a prescription drug. There are 2 elements there, the sale and a prescription drug. As noted previously, none of that exists here. These are not prescription drugs. The notice and statement alleges on-site administration during a consultation, not a retail sale to a patient, and a prescription drug under NAC 639.010, as the board knows, must bear the RX only legend, which these unapproved peptides do not. That predicate fails on both elements. NRS 639.100 in count 3, no cognizable wholesale distribution offense. The aiding and abetting wholesale distribution theory fails several ways. First, the transaction alleged, a medical practice acquiring peptides for its own use, is expressly excluded from wholesale distribution by NRS 639.0155. Second, the substances are not FDA-approved prescription drugs or products as the federal DSCSA defines those terms, so that the federal regime does not apply by its own terms. And third, and most basically, NRS 639.100 targets sellers, manufacturers, wholesalers, dispensers, not purchasers. The board has identified no Nevada statute that makes it unlawful to buy from an unlicensed wholesaler. NRS 639.595 says such a purchase is not a bona fide transaction. It does not create an offense. Third, and independently, this theory was never charged. The citation and notice and statement charge counts 1 and 2 entirely as dangerous drugs violations. Count 1 is captioned, unlawful purchase, acquisition of dangerous drugs, and count 2, It's captioned unlawful furnishing and administration of dangerous drugs, and every operative allegation for those counts uses those same terms. Nowhere in either document did the board allege that these peptides are parental solutions or cite NRS 639.286, 2806, 639.2807, 639.007, or 639.0105. Put simply, Dr. Holtorf was charged on a dangerous drug theory, and he's prepared to answer a dangerous drug theory. NRS 233.121, Section 1B entitles him to notice of the matters that actually asserted against him. The board can't charge dangerous drugs, watch that predicate fail, and then turn around and try to classify them as parental solutions. And that theory it's raised for the first time in its opposition in the brief to motion to dismiss. What the complaint describes ultimately is the practice of medicine and not pharmacy. There's a more fundamental mismatch. The board's jurisdiction under NRS 639.0124 is the practice of pharmacy, not compounding, dispensing, labeling, distributing, interpreting prescriptions. It does not reach the act of administering a treatment to a patient, but read the notice and statement's own words. It faults the absence of a bona fide therapeutic relationship, the lack of a diagnosis, the failure to determine medical necessity, and the provision of on-site medical treatment. These are physician concepts. Chapter 630, the Board of Medical Examiners. A pharmacist filling a prescription does not diagnose or determine medical necessity. A physician does. When the board sets out to judge whether a therapeutic relationship was bona fide and whether the care was medically necessary, it's adjudicating the medical standard of care, which is not the board's to adjudicate. If the concern is that someone practiced medicine without a license in Nevada, that's the medical board's matter. It doesn't convert medical care into unlicensed pharmacy because a needle may have been involved. The board's only merits theory, parental solutions, is unavailing. In its opposition, the board advanced a single affirmative theory that the peptides are parental solutions whose sale and compounding were restricted by NRS 639.2806 and 639.2807. NRS 639.2806 and 2807 appear nowhere in NRS 639.2895's list of 4 predicates. Even if this were a parental solution violation, and it's not, the board would have no power to cite or fine an unlicensed person for it. The theory never connects to your penalty authority. Both statutes govern only parental solutions used in a patient's home or in a facility for the dependent or a medical facility other than a hospital. Home infusion and long-term care settings. One of them even requires a registered nurse on call for the patient at home. A vendor booth on a convention floor at a Las Vegas hotel is none of those places. The statutes do not reach that conduct. And there's an issue with the parental solution classification. The notice of what the parental solution pivot concedes, it abandons dangerous drugs. The board's opposition never once cites NRS 454.201. Retreating to the generic drug and parental solution definitions is an admission that these substances are not dangerous drugs, which is fatal to count 1 or 2 of the operative complaint. A drug given by injection is still a drug given by injection. The root is not a new category, and a needle is not pharmacy. And finally, the notice and statement charges each count against Dr. Holtorf and employees or agents without ever saying what Dr. Holtorf personally is alleged to have done. NRS 233B.121, Section 1D requires a short and plain statement of the matters asserted, and due process requires enough specificity to prepare a defense. So our request here is simple. It's a request to apply your own statute exactly as it's written, grant the motion to dismiss, deny the motion to strike, rescind the cease and desist orders, the citation and fine, dismiss the complaint with prejudice. Thank you.
And Todd, before you move to this is a ruling for Helen, right? So just so the board, I just wanted the public and the board to understand, we might have missed that and it's assumed because Helen knows what's going on and you do. Can you explain what is actually happening here?
Yeah, this is senior deck topic. So these are preliminary matters, these motions, but these are for decision by the chair only, not for the vote. For the vote will be if we have to do a hearing, but as far as just for President Park.
Great. I will turn it over to Mr. Cant.
Brett Camp for the record. Arguing the motions on behalf of the state as I indicated, although Ms. Tucker will be prosecuting the case. First of all, I want to note that on the issue, the preliminary issue of pre-hearing motions, the Administrative Procedure Act, which governs the proceeding, doesn't provide for pre-hearing motions or pre-hearing practice. And the problem is that the respondent seeking preemptive dismissal of the citation prior to the statutorily required appeal hearing that he himself requested. But nevertheless, what I'm going to ask be provided to you and entered into the record, and obviously counsel has the right to object, is by way of brief background. While this motion that's before you is pending, the respondent filed a petition for a writ of mandamus or prohibition in the Nevada Supreme Court. And the court issued an order denying that petition. And I would like to have the Supreme Court's order denying the respondent's petition provided and entered into the record, but counsel may want to object.
No objection.
Okay, so staff is going to provide you a copy of the Supreme Court's order denying the petition. And the reason I want this made part of the record is because I think it illuminates a very salient point here. If you look at page 2, it's only a 2-page order. And if you look at page 2 in the last paragraph of the Nevada Supreme Court's order, you will see that it says in pertinent part, quote, "It is not clear from what is currently before this court that the board lacks subject matter jurisdiction over the matter before it. And the board has not yet addressed petitioner's arguments against jurisdiction yet." So, end quote. So the court itself, when presented with the same arguments that are being presented to you now in this motion to dismiss, said it wasn't clear upon their review that the board lacks subject matter jurisdiction over the respondent. But moving on to some of the substantive arguments that have been made, I want to, first of all, note that there are some rules of statutory construction that come into play here that are well established. One, you go with the plain, unambiguous language of a statute. Two, you read multiple statutes in a way that avoids conflict and allows them to work harmoniously and carry out the legislative intent. And three, you should never read a statute in a way that makes any portion of it meaningless or that produces absurd and unreasonable results. And so when you look at the statutory basis for the citation and fine against the respondent, once more you go back to the statute in question itself, 639-2895, and specifically its reference to NRS 639-101A. And the board's authority to cite and fine extends to any person who may dispense or permit to be dispensed a drug who does not hold the appropriate certificate, license, or permit required by this chapter or chapter 454 of NRS. And both those chapters make it clear that a drug in pertinent part can only be dispensed by certain persons. And that includes a practitioner, but the chapters require, the law requires that that practitioner be licensed to practice their profession in this state. So if practitioner, and let's also clarify for the record that dispense, the statutory definition of dispense includes possession and administration. So for a practitioner to possess and administer a drug to a patient in Nevada, they have to be licensed to practice their profession in the state. And if they're not properly licensed to practice their profession in the state, the board, pursuant to the express plain and ambiguous language of 2895 and 639-101 subsection 1A, has the authority to cite and fine that individual. And I also want to touch on this issue of drug. There's a statutory definition of drug. It's broader than just a dangerous drug or a controlled substance. It's in NRS 639-007. And that's the conduct that took place here. So the board's jurisdiction, also we're talking about, council's made arguments, this isn't the practice of pharmacy. Rather than get caught up in that argument, I will just note that the board's jurisdiction extends under NRS 639-070 subsection F to regulating the sale and dispensing of drugs. And once again, that definition of dispensing includes possession and administration to a patient. And under subsection L, enforcing chapters 639 and 454 of the Nevada revised statutes. So the board has clear jurisdiction over the activity that took place here for which respondent was cited. I think that's all I've got in response. Thank you.
Do a quick reply to some of the issues, please. So to start with, in terms of the Supreme Court's order, what the Supreme Court said is the jurisdictional issues are not clear, not that they made a ruling on that whatsoever. So while I have no issue with the permission to enter it into the exhibit, it shouldn't be given weight because there wasn't a clear ruling on the jurisdictional issues. And that's what we're here to do, and that's what we're talking about before the board. Council briefly raised an issue about what permit is, and permit has both an active meaning, authorize, consent, make possible, and a passive one, tolerate or fail to prevent. State versus McBride, because permit can be read either way, a person of reasonable intelligence could not know what behavior the statute prescribes. Thus, as applied, does permit to be dispensed require that Dr. Holtorf affirmatively authorize the injections, or merely that as owner he failed to prevent them? The statute doesn't supply notice and a fair opportunity to answer. Read passively, permit would compound the defect by importing transferred intent. This is one of the issues in this case, punishing Dr. Holtorf on the basis of another person's state of mind, and punishing Dr. Holtorf when it's not clear that he himself ever committed any of these acts. There's an agency issue. All of the acts of the administration of the peptides, it's important to note, were done by two other individuals, one of whom was licensed in the state of Nevada, advanced practical registered nurse, Mr. Linders. And permit requires assent. Even if the permit to be clause isn't vague, it still can't reach Dr. Holtorf because permit carries an element of assent the statement never alleges. In State versus Robinson, where the court held the word permit includes the element of assent, a store owner who employed a non-pharmacist instructed him not to sell drugs and was absent when the charged sales occurred, could not be held penally liable for the acts done without his knowledge and contrary to his instructions. So Dr. Holtorf stands precisely in that position here. He's being placed at jeopardy for acts done by another person and not by him as the actor himself, which is statutorily not permissible. That's it. President Park, do you mind if I ask a question or two of council?
Oh, I think Laura has something to say too.
Yeah, Lauren Taylor for the record, if I can add also, that, Mr. Alexander in his argument, admitted that the cyanocobalamin is a drug. And so that's enough to deny the motion to dismiss because we allege that, the patients were injected with cyanocobalamin. And so that is itself a dangerous drug and that is unlicensed practice.
Just one quick note on that. Again, that is not a dangerous drug. We conceded that it was a drug, but not a dangerous drug. And Dr. Holtorf was charged with dangerous drugs, not drugs.
Yeah, no.
This is Senior Dag, Todd Weiss. Madam President, is it okay if I direct a couple questions to council? I have questions for both.
Yes.
I want to start with Dr. Holtorf's counsel. Counsel, you said that the board, and I said the board, the Madam President shouldn't put any weight into the Supreme Court decision. But my question is there any argument that you have made to us that you did not make to the Supreme Court? I don't have the petition directly in front of me, but, you know, I think there were some different issues that were potentially raised, but again, in the Supreme Court decision, they declined really to adjudicate any of the substantive issues, and that would be our position on that. Well, I mean, and then the president can read it how she feels, but when we're saying we don't see clear evidence that the board lacks subject matter jurisdiction, isn't that what is required at this stage of a pre-hearing motion when no evidence has been admitted, when there's been no testimony? There has to be a clear finding that there's a lack of subject matter jurisdiction at this stage. I mean, we're in a pre-hearing motion stance. Is that what the Supreme Court is saying here? So mandamus, remember, is a more extraordinary remedy, and that's what we were asking the Supreme Court to issue. It is a different standard than a motion to dismiss. So I would note that there's a distinction in the remedy that's requested and the threshold to get that remedy, which is again why I don't believe that the Supreme Court decision should be afforded any significant weight, especially absent a clear ruling on jurisdictions. Not clear, plain language indicates that it is not clear. It's still a muddled issue, and they did not make a decision on the jurisdiction line. And I understand that, counsel. Would you agree that at this pre-hearing stage that the clarity standard is also how President Park should be evaluated? If the issue is not 100% clear that you are correct, you're asking her to rule on that motion when we haven't had any hearing, when we haven't had any evidence, we haven't had any testimony. I mean, what standard would you expect President Park to review this motion on? The standard that's in the operative complaint. That's why we referenced the operative complaint several times. So the operative complaint makes it clear as to what was charged, which were dangerous drugs, which we're saying these are not dangerous drugs and fall outside that category. And the operative complaint itself does not place Dr. Holtorf as an actor of the administration of these peptides. And that's where the permit standard comes from and the argument about that being constitutionally vague. So I think the standard for a mandamus is not the same for a motion to dismiss. That's going to be an issue for how Dr. Park wants to make a decision on that. But there are two different standards. And in terms of what I would ask the board to look at is what the charging instrument says. And the charging instrument is not clear, or it is clear that Dr. Holtorf did not administer any of these acts. And the statutory references are clear that these are not dangerous drugs.
Can I ask one? You had asked me for the actual cite and find because it wasn't in the board book. I don't know if that was a copy provided or we were going to wait for this. So it might be appropriate if both parties can agree that we would give the president a copy of the cite and find. Mr. Alexander, do you have an objection?
No,
no objection. So, and I think there's copies for the board members. You can give them to everybody. It's a matter of public record. So.
Greg Camp for the record. Yeah, if the cite and find's not in the board book, I didn't realize that. We need to make that a part of it.
Yeah, we did. We were just waiting for this time to present it. So. And there'll be a copy for the public. Todd, did you have questions for Brett too?
Um, can you explain to me, are we saying there is no distinction in the complaint between dangerous drug and drug?
I'm going to let Ms. Tucker answer that because she's the one who drafted the complaint.
I think there is sorry, Laura Tucker for the record. So there is a path, there is a path where the definition of drug includes dangerous drug. So dangerous drug is just a component of drug. And, you still need to, under Nevada law, in order to administer certain types of drugs, you still need to hold a license, either with the Board of Pharmacy, or you need to be licensed both by your primary board and Board of Pharmacy. And the allegation is that no one involved, including Dr. Holtorf or anyone that was working at Holtorf Medical Group, possessed the necessary licenses, all of the necessary licenses needed to administer any drug in the state of Nevada.
And possess any drug. And possess any drug.
Yes, Laura Tucker for the record. So the definition would be, it would include possession, furnish, administer. Any other questions?
That's all right.
All right, so based on the information in front of me, so I do believe that the Board of Pharmacy has jurisdiction and authority over this matter. I do believe that from the cite and find that Dr. Holtorf and his medical group was engaged in an unlicensed practice. Regardless of the argument about drugs, dangerous drugs, peptides. Mr. Alexander did mention the vitamin B12, which does qualify, I think, as a drug and dangerous drug. And so with that, there's clearly unlicensed practice. And then furthermore, with the decision from the Nevada Supreme Court, I think also reaffirms that the jurisdiction is within the board's realm. And so with that, the motion to dismiss is denied. Do you have any other preliminary motions?
We have a second motion to dismiss. Discussing some different issues that should be before the board.
Do you want to take a break and get you ready to go? Okay.
I have a titled respondent second motion to dismiss.
Respondent's second motion to dismiss raises a further threshold question about the board's own power. Round one, the board cannot find a non-licensee. Its only authority over an unlicensed person is NRS 639.2895, which is and must be strictly construed. There's a case out of New Orleans titled Dyer, which is similarly on point to the issues presented here, which held a licensing board cannot find a true outsider, and that power is for the courts. Dr. Holtorf never held, applied for, or was eligible for any board license and cannot cure by obtaining the proper license. Round two, the penalty never switched on. Even if section 639.289 is valid, it applies only if the board determines a person violated one of the four named sections. Again, the peptides are not dangerous drugs under the closed 454.201 definition. No qualifying sale on wholesale distribution is alleged, and Chapter 454, Title 15, and the federal CSA counts appear nowhere in 639.2895. And round three, section 639.2895's language of each activity, a separate offense with activity undefined, is unconstitutionally vague. So when we look at NRS 639.2895, it cannot reach Dr. Holtorf, even though it refers to unlicensed persons. It is limited to a person who could obtain a proper license to cure the alleged violation. It's not unlimited in scope. The board is a creature of statute. It has no common law or general police power. Only such powers as have been conferred by law expressly or by implication. And those grants are strictly construed. The board's general protection of the public provisions, the ones the opposition cite, such as NRS 639.070 and NRS 454.366, cannot enlarge the specific grant. The one and only statute that gives this board any power over an unlicensed person is NRS 639.2895. That statute does not reach Dr. Holtorf. Again, the most relevant authority is Dyer versus Louisiana State Board of Dentistry. There, a dentistry board did precisely what the board seeks to do in this case. It held a hearing, found a laboratory technician guilty of unauthorized practice, and fined her $5,000 per account under a statute that on its face authorized penalties against any unlicensed person. The court vacated that fine. It held the board had no jurisdiction to sanction a person who neither qualified for nor was ever issued a license. A licensing board's disciplinary power, the court explained, runs to those inside the licensing relationship, current and former licensees. The punishment of a true outsider for unauthorized practice is reserved for the district courts because that punitive quasi-criminal sanction is the work of the courts, not an administrative agency. There are statutes to punish unlicensed practice, and that's what should be applied in this case. Dr. Holtorf resembles a plaintiff in Dyer. He's a California physician. He never held a Nevada board license. He never applied for one. The board issued him nothing and can revoke nothing. And here's the tell. Written into the statute itself, the cease and desist remedy runs until the person obtains from the board the proper license, certificate, or permit. NRS 639.2895, Section 1. That remedy assumes a respondent who can cure the violation by becoming licensed. An unlicensed pharmacy that can become a licensed one. It is incoherent as applied to a physician who cannot obtain any board license to practice medicine because none exists. The remedy tells you whom the statute was written to reach, and it was not written to reach Dr. Holtorf. For this reason, 639.2895 cannot reach Dr. Holtorf. It's limited to a person who could obtain a proper license to cure the violation. And ground 2, suppose the board is not persuaded that its power stops at the edge of the licensing relationship, it still cannot reach this case because the penalty power in 639.2895 is conditional. It arises only if the board determines that a person has violated one of 4 specifically named sections. NRS 639.100 Section 1, 639.2813 Section 1, 639.284, or 639.285. There's no free-floating authority to fine unlicensed drug activity in general. If the conduct alleged does not fit one of those 4, the penalty power does not switch on. And it doesn't fit. 2 of the charged counts depend on the premise that the peptides are dangerous drugs, not just drugs. And there is a distinction between dangerous drugs and drugs. They don't run synonymous with each other. It's a legal term with a closed definition under NRS section 454.201. So the term dangerous drug is enumerated. Dangerous drug is one of 3 things again here. FDA approved drug, Gerovital H3 or Latrol, or a drug the board has classified by its own regulation after finding it dangerous. There is no relate back to another statute that allows then someone to be charged with a dangerous drug that converts it automatically to drugs. There are 3 categories, and those categories enumerate what a dangerous drug is, what a dangerous drug presumably is not. And here, the peptides in question, MOTS-c, P21, BPC, etc., they're none of the 3. They don't bear an RX legend, they're not FDA approved, and none is one of the 2 named substances. This board has never adopted a regulation classifying a single one of them. And indeed, even the FDA has not decided what these substances are. The remaining predicates fare no better on the statement's own facts. No sale of prescription drug is alleged under 639.285 and the wholesale distributions of 639.100 are not made out, and the great mass of what the complaint cites, which is in the chapter 454 criminal statutes, the title 15 felonies at NRS 200.820 and 200.840, the federal DSCSA provisions, appears nowhere in NRS 639.2895. Those are not predicates for this board's administrative fine at all, and as a matter of law, they should be dismissed or stricken. This ground asks nothing of the board except to read its own statute. Doesn't require the board to accept the word I've said about Dyer. Even if a board fully competent of its own power over non-licensees must dismiss if the four-corner trigger is unmet, and here it is. There is a third reason, and I want to be precise about what I'm asking and not asking. I'm not asking this board to declare a statute unconstitutional. The board's opposition says that it's not its role, and for today's purposes, I accept that. What I'm asking is different, squarely falls within the board's job. Where a statute can be read two ways, one raising grave constitutional doubt and the other avoiding it, the board should choose the reading that avoids the doubt. The canon of constitutional avoidance points to the very same narrow construction that I've been urging. And I ask the board to note our constitutional objections to the record so they're preserved under NRS 233B.130. The doubts are serious. NRS 639.2895 says each activity constitutes a separate offense, but never defines activity. That single undefined word is both a trigger for liability and the multiplier that sets the size of the punishment. No one, not Dr. Holtorf, not the board, can say in advance whether a 3-day booth is one of activity, 3 or dozens. Courts have condemned this word as void for vagueness. The same defect is a standardless delegation. A $5,000 ceiling means little paired with unbound multiplier, no aggregate cap, leaving the essential policy judgment and how severely to punish to the same body that investigates and prosecutes. The board can sidestep these issues by construing the statute narrowly as it should. And I want to say another word about the agency issues. Again, in the operative complaint, Dr. Holtorf does not administer anything. What the board seeks to do is punish a California physician for activity that is being done by other licensees, presumably one of which is licensed in the state of Nevada, and an APRN can, in fact, administer B12 injections. That's not forbidden. So to say that the B12 itself carries this case over, I would argue that it does not. And moreover, to impute conduct to Dr. Holtorf that he himself did not do raises serious concerns about agency and vicarious liability that's being applied to Dr. Holtorf when he himself did not engage in any of the conduct that's alleged in the complaint that's being done by other licensees, one of whom is licensed in the state of Nevada. So that's it.
Brett Camp for the record in response. And to some extent, we are relitigating some of the prior issues that were raised and considered on the first motion to dismiss. But I want to start with this is why pre-hearing motions, dispositive motions are problematic. The board's job is to hear the evidence and make findings of fact and conclusions of law and determinations. And we're digging into those issues beforehand, before you've even heard the evidence. And that's problematic. And that's why I think it's appropriate to let the board fulfill its statutory duty to hold a hearing. And then if the petitioner feels, or excuse me, the respondent feels aggrieved by the board's final decision, they have a remedy. They can file a petition for judicial review and seek a district court's review of the record, the evidence, and whether it was sufficient or not. And I would note that in that event, whenever a party seeks judicial review, the board stays enforcement of any order it issues, and that would include in this instance staying enforcement of the cite and fine. But getting back to the arguments, once again, I make reference to the principles of statutory construction that guide courts and also guide you in your application of the law in your role as the Board of Pharmacy. And that is plain and unambiguous language. Don't read a conflict where one doesn't exist. Read them in a way that they work harmoniously together to fulfill legislative intent. And don't render any part of a statute meaningless or in a way that produces absurd or unreasonable results. Going back to the operative statute here, the cite and fine statute, 639-2895. That was enacted in the 2013 session by Senate Bill 220. And this notion that your cite and fine authority is negated or abrogated in any way by the fact that you're also granted injunctive authority or that there are criminal penalties for certain conduct. That's not reading all these statutes in a way that gives effect to all of them, and in a way that is harmonious and consistent with legislative intent. You've had the authority to issue an injunction since 1967. You were granted the authority to issue the cite and fines for unlicensed activity in 2013 with the enactment of Senate Bill 220. And I can tell you, because I was involved in the bill, the purpose of the bill was to make it clear to regulatory boards that license and regulate activity in Nevada, make it clear to them that they had a mandate to go after unlicensed activity, they had the authority to go after unlicensed activity, and to give them the tools they needed to go after unlicensed activity. So it added to your existing tool of seeking injunctive relief for violations of the law. It added this cite and fine authority. It also enacted many of those criminal penalties. The same bill, the same. So the notion that the criminal penalties somehow canceled out the cite and fine authority simply doesn't make sense. They all work together. They're all tools in the toolbox to be used by appropriate Nevada officials and agencies to go after unlicensed activity to protect the public. And once again, I've said it, but read the language of the statute and incorporate, once again, the language of NRS 639-101A, that no person shall dispense or permit to be dispensed, and that includes possession and administration to a patient, any drug in Nevada, unless they hold the appropriate certificate, license, or permit required by law. It doesn't say permit that you issued or license that you issued or registration that you issued. It just says they have to hold the appropriate permit, license, or certificate. And in this instance, if a practitioner wants to possess and administer a drug in Nevada, there could be one of several registrations or licenses they could hold. If it's a controlled substance, that's not an issue here. They get a registration from you. If it's a drug, they at a minimum have to be licensed by the Nevada State Board of Medical Examiners. So this notion that, well, you can't go after him for this activity because he doesn't have to be licensed with you to dispense a dangerous drug or a drug, excuse me, let's just use the term drug in general. That's not the requirement. He could obtain a license to practice medicine in Nevada from the Nevada State Board of Medical Examiners and therefore lawfully possess and administer drugs to Nevada patients. But he didn't do that. And so you have the authority to cite and fine him for the fact that he didn't do that. Or he permitted to be, because once again, that's one of the arguments. Well, he didn't actually do it. Others did it, but they did it at his direction. They were his employees. He employed them for the purpose of possessing and administering drugs to patients in Nevada. That falls clearly within the language of the statutes. And so, once again, reading the plain language of the statute in a way that makes sense and that's consistent with legislative intent and doesn't render any of it meaningless or absurd it's clear that the board had the authority to cite and fine respondent for this conduct in this instance. I want to note that council made reference to some Louisiana case law, which follows whatever Louisiana's statutory language is. Doesn't matter here. It's irrelevant. Now, what matters is the express language that you're operating under here. And I think that's all I've got. Thank you.
So quick reply. So one of the issues here again is that the notice and statement recites that Dr. Holtorf violated or attempted to violate, assisted or abetted in the violation or conspired to violate the predicates. That is besides the point. 639.2895 authorizes penalties only on a determination that a person has violated a predicate, not that she attempted, assisted, abetted, or conspired. There isn't conspiracy liability under 639.2895, and there is no aiding and abetting citation power. And so, to Mr. Kant's point on pre-hearing motions, the operative complaint in any case is very important. And in this particular case, in count 3, as I just noted, the attempted, assisted, abetted, or conspired, it's not authorized by statute. So it doesn't require, as my colleague next to me stated, digging into the issues. It just requires looking at the complaint on its face and seeing if it is statutorily and constitutionally affirmed. And that's what we're asking the board to do, is to look only at the complaint. And even in the complaint, as we said, there is this argument about permit. And again, my colleague on the next to me talked about an absurd result, but permit is not very clear. Does it require that Dr. Holtorf affirmatively authorize the injections, which there isn't any evidence of that in the complaint, or that he merely as an owner failed to prevent them? Again, that would produce an absurd result, because what permit does or says, or what Dr. Holtorf's responsibilities are or are not, is not clear. So again, there is concerns about every operative allegation pled against Holtorf, Dr. Holtorf, regards Holtorf or employees or agents of Holtorf Medical Group, HMG. The specific acts, purchasing, storing, compounding, furnishing, and administering peptides, and giving the injection, and that's again clear in the complaint, they are attributed to Dr. Wynn and APRN Daryl Linders. And thus, there isn't any direct liability or nexus between Dr. Holtorf and the acts of which the board seeks to impose a disciplinary action.
Greg Kemp for the record. Could I add one final comment, understanding that council gets the final word on the motion arguments?
Yes, go ahead.
Okay, once again. Okay. There is a case that does apply to you. It's a case that you're very fortunate to have. Duchess Business Services versus Nevada State Board of Pharmacy, case that the Nevada Supreme Court handed down back in 2008. And it's very illuminating, I think, times when you have to make some decisions in the course of an administrative hearing as to how to go. But the point I'm trying to make is this. The respondent's entitled to notice, the basis of the citation fine, and an opportunity to be heard to challenge it. And in the course of determining whether those due process requirements are made, the court and Duchess used, I think, the term that should always guide you. And that is, there should be no unfair surprise to the party that's been charged with violating the law. And so that's what I would submit to you as your standard today. Has there been any unfair surprise to the respondent in this case as to what they did and why it was unlawful? I would submit there's not any unfair surprise. I would submit that under that standard, this should move forward in a hearing. And we're litigating stuff for the fact that you can make determinations on, and findings of fact and conclusions of law after you consider and weigh the evidence that would be presented at a hearing. Thank you.
Mr. Alexander?
While I understand that argument, again, similar to a motion to dismiss in a civil case, if the conduct charge does not fit or fall within the statutory interpretations as charged, then the board has an obligation to dismiss the operative complaint or the components of the complaint that do not fit the statutory definitions of the charges against the respondent. And here, as noted again, the substances as issued are not dangerous drugs. They don't fall within that category of definition. And then in count 3, the attempted, assisted, abetted, or conspired is not authorized. And so thus, even though while I understand those arguments, if in fact the board is charging conduct that it's not statutorily authorized to do, this is the appropriate way to present that issue to the board, because it's a purely legal argument. And I believe that the board has the responsibility to look at this and weigh out whether or not the charging instrument does fit or fall within the categories as charged to Dr. Holtorf, because any respondent is provided and afforded notice. And notice means that the charged conduct must be in the complaint, and that charged conduct is accurate. It can indeed be charged, and he can or she can indeed be held to account for the acts as prescribed. In this case, as we said, the complaint is deficient as to dangerous drugs, and it is deficient as to agency liability because Dr. Holtorf himself did not commit any of the acts that are alleged to have occurred at this expose approximately 1 year ago.
Great. So first of all, in reading the plain language of the statute, which I have in front of me, I think it is clear that the board has authority to cite and fine any unlicensed practice. In hearing what you shared with us, Mr. Alexander, it indicates to me that we need to hear the evidence versus just hearing components that you are speaking of. And looking at the complaints, I think that they are appropriate. And I think that the next step in order to ensure that this board is protecting the public, the safety of the public, that we should move forward with the hearing. So your second motion to dismiss has been denied.
There's no other issues to do today? Okay. So that's closed. We'll continue to work with the parties. We have one more item if you want to just go to it, and then maybe we could take public comment, or if you want to break first and come back for that, it'd be either way. We have time, the way you want to do.
We'll take a quick break. Thank you. We're going to continue with our Board of Pharmacy agenda. We're going to go to 12D, and that's for eSurgical LLC. If we have representatives online or in the room for eSurgical LLC, if you could please have your, okay, see some individuals.
Yes, this is Tina Low, and this is Jen Liu.
Great. Will anyone else be joining you too?
No, just us, just two of us.
Okay, great. I'm going to go ahead and swear you both in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
Okay, great. Thank you. And with that, I will turn this one over to Ms. Young.
Thank you, Madam President. This is Skylar Young for the board. Agenda item 12D, application for a new wholesaler, starts on 9/7/96 of the board book. Today we've got Tina, who is the designated representative and also the MDEC, and then also Jane, who is the owner of eSurgical. I just have a few questions for you guys as we go through your application. On your first page, you guys state that you're providing medical products, and then also it'll be e-commerce. Can you explain what that means? What does e-commerce mean for you guys? And will you actually have a warehouse?
The e-commerce that we are working on the website that will allow the practitioners or clinic to register and place order online. And the warehouse, because basically e-surgical is located at an address that is a business office. So we contract the warehouse service to Nuditronics.
So you guys aren't a third party, you are, the e-commerce aspect is how you conduct your business, is through online sales.
Correct.
You also have, like you mentioned, an office address at 150 Isadora Court, and then also later on a warehouse address of 1 New Detronics Way. Can you explain how those are related, those two addresses are related, and also your role in New Detronics?
There's one question, Skylar, you said the street address, but what's the city and state for those? Just
I apologize.
No, you don't need to apologize. I
This
just
is in
didn't.
Sparks.
They're both in Sparks.
They're both in
Just want to
Sparks.
make sure that the board knows. Thanks.
So could you guys explain those two addresses, number one, and then it does look like you guys both currently work for New Detronics as well. And just explain your current role with that company.
E-Surgical is a distribution company that we set up as an e-brand. So it's set up as an e-Sentry, and we are doing a lot of electrical surgery, IF-based device. And Nuditronics is our, we have parent company in Taiwan for manufacturing, and here we do warehouse for e-Surgical. So this is the first time we're going to sell e-Surgical products through the e-commerce from website. So that's why we applied for this license.
So is e-Surgical related then to New Detronics?
Yes, we are affiliate companies.
And currently, what is New Detronics doing today?
Nuditronics is a medical device design, manufacturing, and distribution company. It was founded in 1985, and then 87 set up in Taiwan doing all the manufacturing. And now we are trying to set up here in Made in USA. So we are in the process. We had a building done, and we are in the process try to manufacturing here.
So I will note that this building has been done for a while, and at first thought, I thought they must have a license, but they're not doing anything right now.
No.
But I did advise that New Detronics will need to get a license with us once you guys start operating.
Yes. Yes.
And then also, can you tell us, are you only going to be getting devices from Taiwan? Is that where the medical devices?
Currently, yes. But after we set up better and get more certification for Nuditronics, we will try to made in USA.
I see. If you do continue to ship from Taiwan, that location will have to get a license as well.
Yes, definitely. I think first what we familiar with is that we get FDA registered as a GMP facility, and then get all the ISO certifications. So there's a lot for us to learn how we deal with in here. Yes. So we need for guidance.
You could definitely talk to us for that, and then talk to our licensing department. So right now, it does sound like you guys are a little early on, but you have the devices that you'd like to provide, and also the warehouse location. Can you talk a little bit more about those devices, the electronic surgery devices?
It's an IF surgical device, which is, when you have operation, traditionally use knife to cut. And so this is electrical surgery pencils. So you will, cut it and then coat it, stop bleeding. And we have another accessory, it's called grounding pads. It's like a return pads. So this is a basic legacy electrical surgery device. So all the devices shipped over here are meeting the FDA requirements. Those are FDA 510(k) cleared. And we also have completed the listing requirement.
Great. Sounds like you guys both have a lot of experience with these devices. How do you guys plan on getting clients?
Tammy, clients. This is why we drew the e-commerce that our target is like a private clinic, professional doctor's office, and then maybe develop more with the pet. Yeah.
I think our team is still working on the marketing strategy, like through the social media marketing or email, that kind of thing. So the people can search when they search online using the keyword, like our company information will be showed up on the options for them.
Thank you. I don't have really many concerns outside of additional other applications before this gets moving. So I think that's questions.
I just have one other question. It's really for Dick, but because the pharmacist knows. But I had a surgery once and I got a bill for the grounding device and I didn't really know what it was. And so that's what keeps you from bursting into flames when they're using the electronic knife. So it's very important that we have the grounding device. So thank you. It'd be good that we have some more grounding devices. Okay.
Yeah. Prevent you get burned.
All right, Board, I don't have any further questions. It seems that eSurgical LLC has are taking their steps in identifying the right licensure and are seemingly going in order. So I don't have any additional questions.
I don't either. I was just gonna comment that I've seen the facility at New Deantronics Way. It's very close to my house. It's
Oh.
big and beautiful.
Okay, great.
Thank you.
Very good.
Adam Porth, for the record, I would move that we approve wholesaler license for eSurgical LLC.
Great. You guys are helping me.
Oh, we're not quite done yet.
Well, we'll let you say something
I thought
at
it
the
was
end.
done.
Yeah. So we have a motion by Mr. Porath, a second by Ms. Taylor. Any further discussion? Okay, hearing none. All those in favor?
Aye.
Any opposed? Okay, that motion passes.
Just for the record, I think we said it, but Jade's not on the meeting right now. She's been excused for an illness, so.
Your application has been approved. Thank you.
Thank you.
Cassette was a fire in the button.
Thank you so much. All right, have a great day.
All right, Madam President, that's what I have for you. We've gotten our other agenda items done. We just public comment and then we'll be prepared for tomorrow.
Okay, great. So as our final order of business, the board will open up the floor for any public comment. If there's anyone in the room or online who wishes to make a public comment, please feel free to come forward now or raise your hand in Zoom or let us know through the chat function. Okay, I don't see anyone in the room. Is there anyone online?
I don't see anybody online, Madam President.
So we'll close this period of public comment. That completes our agenda items for today. We'll reconvene tomorrow morning at 9 a.m. Thank you.